I'm David Crawford. I'm a partner in the Real Estate Strategic Joint Ventures Group at Procopio, coming to you live from the 19th floor of the Procopio building in sunny downtown San Diego. A little bit of biographical information about me. I like cooking. I like baseball. I like tornadoes. I like water, so you'll see me drinking water. In terms of my practice, I've been practicing for about 11 years. You could call me a real estate generalist, but over the years, I've come to represent a varied number of life science companies engaged in real estate transactions. And it's some of my favorite work to do. Although I'm not a scientist, I can ask questions and I can learn, and I work with brilliant people, and I learn something new on every deal. And what more could you ask for? So today we're going to talk about key issues in life science real estate. We'll kind of give an overview or a broader picture. Then we'll spend most of our time on leasing and key kind of hot topics in leasing or key topics in leasing, since that is the real estate transaction that most life science companies will engage in. We'll also talk a little bit about financing for companies that own real estate. And if we have time, and I anticipate we probably won't have time, we'll talk about development and building your own building. I used to be a real estate developer. If we don't get to that, I'm happy to talk about that later. All right, you can email me and ask me any questions. So what are we talking about? What am I talking about when I'm talking about life science real estate? Well, a lot of the things are the same. You have a piece of land and you have operations within four walls and a roof, and architects need to design the building and contractors need to build the building, and it takes the same utilities, and a lot of the legal issues are the same. So why have this webinar specific about life science companies? The short answer is its own category of real estate. The traditional categories have been residential, office, industrial, hotel, and public use. But over the last couple decades, there's research and development and sort of high-tech manufacturing in the biotech space, let's say, have become a dominant mode or a dominant force of real estate, especially here in San Diego, in San Francisco, Seattle, and Boston. And it is different. An R&D building is to an office as a hotel is to an apartment building, which is to say it's just more complicated. So what is different? Well, laboratories and production facilities, they require specialized construction and engineering skills that go into them. Installing the clean room is an unusual thing for people to do outside of the R&D real estate world. Validation, good manufacturing practices is unique to life science uses. All buildings need to be inspected by a building inspector, but very few need to be inspected by the federal government. And because part of that validation process is really hinging on the four walls and roof you're in, more attention needs to be paid to that. Utilities are critical. If the power went out here in the Procopio building, all of us lawyers would go home and we could work for there. But for a lot of life science uses and research and development, you can't just go home and continue that. You need physical space. Loss of inventory is consequential. You may have experiments in progress that could be interrupted by loss of utilities, let's say. It's a little bit different than, again, a law firm that maybe their computers are destroyed and everything's online anyway. Really expensive equipment is in these buildings sometimes. Again, comparing it to our law office, we've got some laptops and some printers, but you may have bioreactors and clean rooms and modular rooms and things in some cases where the equipment is worth more than the building itself. Life science companies use hazardous materials. That's not common to the other categories of real estate. In office, residential, leases say you can't use hazardous materials, but most research is going to require hazardous materials. And when a lease talks about hazardous materials, it's not the super hazardous materials, it's down to things like rubbing alcohol. Vivariums, I cannot bring a pet to work, but I especially can't bring lab mice to work. So a vivarium is definitely a unique use and needs to be dealt with specifically in the situation, in the transaction. Put simply, growth requires additional physical space. in the industry. I've certainly worked with tech companies, and they can scale very quickly by having people work from home. But until there's science for Zoom, that's not necessarily something that's going to happen. So again, a lot of unique things to the industry that then play into certain legal issues or business points that need to be negotiated. So what are the types of transactions that a life science company would enter into? Well, by far the most common, as I mentioned, is leasing. Leasing has advantages. It's generally a quicker move in. The building's already built. It's sort of built for your purposes. It is generally a shorter term liability just for the term of the lease. It's easier to manage operations. And what do I mean by that? I mean, the landlord's taking care of a lot for you, generally. They may be fixing the heating and ventilation. They may be mowing the lawn and striping the parking lot. All things that you don't have to do sort of internally if you're leasing a building. The downside is there's less flexibility in use. You don't own the building. You're working with the landlord. You need their consent and you need them to do things. And that's sometimes a source of friction. Alternatively, a company could purchase an additional building. Then they get all the benefits of ownership, more flexibility in their ability to make changes, captures increases in market value. It can become a source of financing to get some of that money, that capital put into buying the building can come back out in the form of debt. But it's a long-term liability in that sense, and it's much more liquid as an asset. It's not literally liquid, but a life science campus is sometimes difficult to sell for the amount of money that was put into it to begin with. The company might develop a new building, which has all the advantages and disadvantages of purchasing. That gives them even more flexibility. You can design a campus exactly as you would want it. But it is a risky endeavor. It's a difficult endeavor. It takes a very long time. So those are the downsides of that. And then the last transaction that a real estate company that a life science company might enter into in the world of real estate is real estate financing, which is to say a loan that is secured by real estate. Typically only available if a company owns the building. Rare is the situation where a lease is financeable, although it's possible. It can potentially, because of the cost of real estate, it can potentially raise more money than a business loan or security sale. Real estate campus might be worth 500,000. It might even be worth $1 billion. 500 million might be worth $1 billion. And to be able to extract some of that value in the form of debt is a good way to raise capital. But of course, debt increases risk. I think that should be rather self-explanatory. So continuing on the overview, just talking about timelines, and I'm going to give some rules of thumb in this presentation, but of course, there's always exceptions to the rules of thumb, so much that the rules of thumb become exceptions. But okay, leases, I think there's an underestimation of how long these take to negotiate, but I would ballpark it as 30 to 60 days. And yes, it's dependent on the availability and how quick your lawyer is, but it always seems to just take that long. There's always issues that need to be explored and designs that need to be going on at the same time. So it's about 30 to 60 days. And then as we'll talk about later, most of the spaces that you're leasing isn't ready for you to move in. So there's also a build out time when the space is being constructed. You may be able to buy a building in 60 days, but you have the same build out issues. It's unlikely a company is buying a building that they can move into day one. If they did, that's certainly a quick way to go about it. And a company that builds its own building is looking at 2 to 4 to maybe 6 years, depending on litigation and regulatory issues. So that's kind of an overview of the timeline. A big part of my message here is have a plan and start early. Have a real estate plan and start early. And to give an example of that, and sticking to the world of leasing, a reason to start early. Okay, it's a delicate balance when you're moving from one space to another space. Because on the one hand, you don't want there to be a gap between your lease of one space and your lease of the next space, because then you won't have any place to go. But on the other hand, if there's too much overlap, then you're paying rent twice. You're probably paying rent either on the new space, which you're not using yet, or you're paying rent on the old space, which you vacated. So it's a delicate balance to try to line those things up. Brokers are very good and can be very, very, very helpful at getting that right, that balance right. But in this hypothetical scenario, they've done it just right. They've started 18 months out from the 18 months from the end of their current lease term, they've hired their broker, they're looking for space. They've, maybe 3 months later, they've signed an LOI, and the landlord sends them a draft lease, and then there's negotiations that go on. While they're negotiating the lease, the company is working with the landlord's space planner to do some space planning, to have a basic floor plan of what the space is going to look like, because maybe right now it's just a box. And that's probably the most critical thing, because how are you going to use this space over the next 5, 10, 15, 20 years is frankly the most important thing, more than some of the lease terms. And then let's say 12 months before the end of their lease term, they've signed a lease. And that's great. They've still, the company still has to get some permits, which building permits, which depending on the city, who knows how long that'll take. And then in this hypothetical scenario, they don't have to pay rent on the new space until 12 months after they sign the lease. So they've got 12 months to get permits and build out the new space. And they do that. They're on schedule, and 14 days out from the end of construction, the lease says that the company can move into the new space, their furniture, they can wire it up for telecommunications, they can move in their equipment and start setting that up. And then as soon as their old lease term ends, they're ready to go at the new space that they've leased. And at that point, construction is done. They start operations, and because it's 12 months from the date of signing, they're now paying rent, and they've avoided any overlap at all. Of course, that doesn't always work out that way. There's a lot of variables there. But the important message is there's a plan, and this company has started very early in the process. How about planning for expansion? Part of planning for expansion is negotiating, and this is for leasing, negotiating extension options. These need to be negotiated up front at the term sheet stage. They're part of planning for expansion because at some point the lease term ends, and that's a breaking point when the company can decide, okay, what is it we're going to do next? Are we going to continue leasing this space? Are we going to look for a smaller space? Are we going to look for a bigger space? And there can be basically an option to extend is the tenant can elect to say in a 5-year lease, extend the term for another 5 years at a certain rent, which is maybe the market rent, let's say. And, maybe that's the best option and maybe it's not. And a little secret about that is it often is renegotiated at the end of the term. Maybe you've got one option to extend by 5 years, but you really want the space for another 10 at a certain rent. And so you negotiate with the landlord at that time. But it's important to negotiate these extension options up front because they do sort of establish a bargaining position for each party, because you can always fall back on the extension option. Another part of planning for expansion and growth is to literally plan for extension and growth in the same building you're in. And there's a number of ways to do that, all of which need to be negotiated at the term sheet stage. There is the right of first offer. Okay, and the right of first, let's give a hypothetical scenario where a company is occupying suite 200 and next door is suite 500, a very attractive space that is right next door to them. Okay, a right of first offer, suite 500 becomes vacant. And before the landlord goes to market and starts offering it for lease, the landlord comes to the tenant of suite 200 and says, I'm willing to rent suite 500 to you at a certain rent for a certain amount of time, with these other financial terms. And the tenant then can take it or they can leave it. If they leave it, it's a one-time right. If they take it, simple, the lease is amended based on the terms that were offered and accepted, and everybody's on their way. That's fairly common, but again, it needs to be sort of negotiated up front. Less common is a right of first refusal, which is the same scenario. There's a space next door, suite 500, that becomes vacant. And this time the landlord does go out to market and they say, hey, market, this space is available. And they get an offer, they get a term sheet from company X, and they say, we are willing to rent the space at this amount of money for this amount of time and on these other financial terms. And the landlord says, that's very good. But first I've got to go back to the tenant of suite 200 and say, suite 200 tenant, do you want to rent that space on these exact same terms? And if the tenant says, yes, then again, the lease is amended and everybody goes on. And if they say no, then generally that right goes away. There are some nuances here that can be negotiated around that, and sometimes it's not always a one-time thing. But in any event, those are two expansion options. Also less common is what I would call a true option, which is that the lease itself, the day you sign it, says, tenant, you can take suite 500 when it comes vacant for a certain rent. It's all the same terms, but it's sort of negotiated up front. That's fairly uncommon. But again, it's just part of your planning for the company to grow, to potentially not grow, what's going to happen in the future. I think probably the most important part of real estate planning is it really can help to establish, I'm a tenants lawyer, but it can really help to establish a good relationship with landlords. And what do I mean by a good relationship? I don't mean that you roll over and never negotiate anything. I mean that you pay your rent and you have a good business plan, and the landlord believes in your company, and you know you're reasonable, you're business-like with the landlord. Then they're going to take an interest in the growth of your company because you are the landlord's client. The tenant is the landlord's client. And if the landlord owns a lot of buildings in your city, they can have, maybe they have different spaces of different configurations for different prices available. And whether or not you have a right of first offer, that landlord may come to you and say, hey, I've got this great space over in this other building. That's perfect for you. Do you want it? I'll terminate your old lease. You can move over here. So in terms of real estate planning, that is probably by far the most useful tool. And then before we get into leasing, I just want to emphasize three key takeaways up front rather than at the end. The first one is work with partners who know your industry. As mentioned, life science real estate is really its own category, and it has its own category of real estate professionals who know that industry. So there's a large group of institutional landlords, and this is what they do. They lease to life science companies, they build buildings with laboratories and vivariums, and they know what they're doing, and they know how to build those buildings, and they know what the life cycle of a life science company is. There are construction and facilities managers, project managers. There's some great third-party project managers that can make a company's life easier. And of course, you've got internal people who are involved as well. By far, the most invaluable is real estate brokers. I can't emphasize enough, a good real estate broker who knows your industry and knows the market that you're in is your most valuable resource, more valuable than even your lawyer. And I can't believe I'm saying that, but it's true. And you can see the rest of the list, you know, contractors, architects, do they have experience in this industry? But working with people who are on your team is going to make life a lot easier and simpler. A quick plug for lawyers. Lawyers, we can help. Of course, we're going to review the lease. You know, can you review the lease? Can you redline the lease? Of course, that's a big part of what we do, but we can help with these sort of strategic or negotiation type questions. I'd recommend if you get a term sheet from the landlord that you're comfortable with, that you run it by your attorney. We can help say, you know, it doesn't have this, which is something you should negotiate up front, or maybe it has this, which is like not a great deal, and we can talk about that. Attorneys are a good source for referrals, especially to brokers. I rely on the broker's referrals to other people beyond that, but you know, we do have referrals. We do know people, if that's helpful. And then, of course, we can be helpful when it comes to problems that come up later. Leases are a long relationship with the landlord, and there's often disputes that aren't necessarily litigious, but maybe the lease establishes each party's legal rights in that dispute, and talking to your lawyer can really help you negotiate those. And then finally, I've said it 1,000 times already, but have a plan, start early. All right, leasing. As mentioned, by far, what most life science companies are, it is the real estate transaction they're going to engage in. So I want to make sure that we cover the key issues here, most importantly. All right, the big picture. Leases are negotiable. I'm going to explain what I mean by that. There is no standard form of lease. I mean, in California, there is literally a form put out by a real estate association that is used often. That is a standard form. But that form doesn't work for your situation, and that form needs to be modified for life science use. So there is no standard form. What the landlord gives you, they're expecting negotiation of, generally. There is a lot of things that the landlord will change. on the lease, and they may change them without much discussion about it. So my first recommendation is never sign the lease that you're given as is. You'd be leaving stuff on the table that you could get without even any negotiation sometimes. Leases are long. They can be hundreds of pages that cover all sorts of different scenarios, some of which are more likely than others to actually happen. And they establish a long-term relationship over a long period of time in which a lot can go right and a lot can go wrong. Second point, negotiate key points in the term sheet, the key business issues in a letter of intent or a term sheet, whatever you want to call it. They're non-binding, so legally you're not bound to them, but the custom in the industry is that the parties stick to those terms. And establishing a good relationship means you've agreed to those terms. Does that mean you cannot ever change the terms? Well, no, you're not legally bound to them. But this is where you get the main things you need: extension rights, expansion rights, what the rent is, what kind of operating expenses you're paying. That all comes at the term sheet stage. And having that all set out up front makes the negotiation of the lease itself a lot more efficient, a lot cheaper from a legal perspective, and just takes less time because you've worked out the really big issues up front. All right, a lease is a contract for the use of space for a certain number of years in exchange for a fixed total price, which just happens to be paid in monthly installments. So what do I mean by that? I think it's important to know that if you have a lease that, let's say it's 10 years and it's $10,000 a month, the day you sign that lease, you're making a promise to pay $1,200,000 to the landlord, whether or not you need the space for all 10 years. It is a contract to pay a lump sum in monthly installments. So what am I getting at? Leases are generally, you cannot generally terminate a lease. Occasionally a lease will have an express termination right. Again, it needs to be developed and negotiated at the term sheet stage. But it's sometimes a one-time right that says the tenant between these months can exercise a right to terminate this lease and pay the landlord this much of a termination fee. But what I'm trying to emphasize is that although you are paying monthly, if you don't need the lease after a certain number of months, you're still bound to the lease. There are, of course, exceptions to this in scenarios where you could get out of a lease. And of course, you can always negotiate another outcome with the landlord as a business matter. But the emphasis here is that it is a big commitment. Okay, the covenant to pay rent is an independent obligation. That is fancy lawyer speak for saying once you sign the lease, you're required to pay the rent pretty much no matter what the landlord does. If the landlord doesn't fix something, you still have to pay the rent. If the building burns down, technically you still have to pay the rent, although leases often have terms that say you don't. So again, there are exceptions to this, but the basic principle in real estate law for leasing is that your obligation to pay rent is not dependent on other things that may happen. Another sort of overview on a legal point is that in general, the landlord isn't liable for the risks that the tenant can insure. So that would be damage to your property, damage to persons or injury to persons, and business interruption. So, maybe the roof leaks and it destroys some of your equipment. The expectation is that the tenant looks to their insurance to compensate them for that loss. So, of course, again, there are exceptions to this. There are definitely exceptions to this, but the emphasis should be on acquiring sufficient insurance to pay for risks. Finally, especially in life science business, it's unlikely that you're going to be able to recover damages for things like lost research, lost products, lost opportunities, and lost profits. So if your work is destroyed and you're late coming to market, just know that generally the landlord is not responsible for that. So it's extremely important to work with good landlords and have good utilities so you're not running out of power. Those things become even more important. Briefly, the types of lease facilities. Most of what life science companies will lease are purpose-built offices and research and development facilities. There's a huge number of them in San Diego. A couple of just terminology you'll run into. A turnkey means that the space is ready. The landlord hands you the key and you can start using the space right away. That's turnkey. It's less common. Usually you get what's called a shell. A shell is a real estate term, and all it really means is that the space has 4 walls, a roof, and drywall on the walls, sometimes. And you've got to build everything within that box. And to demystify some of the terms, a cold shell doesn't have heating, ventilation, and air conditioning, and a warm shell does have heating, ventilation, and air conditioning. So what you can expect to find in the market is usually a shell, a box with nothing in it. There's also what's called a built-to-suit space. That's where generally, there's different variations, but generally that's where the landlord is basically offering you a piece of land, and the landlord will build you the building that you want on the land. There's also converted office buildings, which is a building looking for a new identity and a new lease on life. These are just as good sometimes, but they're trickier because they weren't built, purpose-built for R&D uses. So you need to work with your consultants to make sure the floor plans and the structural columns and the utilities are sufficient and work for your potential lab design. And then there's industrial properties, often used for manufacturing. An industrial property is just a box made of concrete or steel. And so, again, there's a lot of build out and a lot of real estate planning that goes into using a box made of concrete or steel. Big part of what gets negotiated in the lease up front is tenant improvements. Tenant improvements are what you do to the shell or the box, what you do with inside the four walls. Just basic terminology, a tenant improvement allowance is money that's offered in the term sheet by the landlord to complete the build out. It's usually expressed as $1 per square foot, let's say $100 per square foot. And it's usually reimbursed to the tenant. So the tenant is often coming out of pocket, and then the landlord reimburses part of the cost. I think one thing to be strongly aware of is that what is offered is not necessarily related to how much it's actually going to cost. Sometimes it is, sometimes it's not. And the final thing is that it's basically a loan from the landlord. What they're giving you is recaptured in the rent over time. So just be aware that it's a loan with an unknown market rate, but an unknown rate, because it's just recaptured in the total rent. All right. So then there's two different kinds of build outs. There's it is what it sounds like. Landlord build means the landlord is the producer. They hire the contractor, they hire the designer, they run the show. And then there's the tenant build, which is the tenant runs the show. The tenant's the producer. Different scenarios there. When the landlord is under contract with the contractor and the designers, you have less control over cost and schedule. If something goes wrong, you can't sue your contractor or your engineer because they're not under contract with you. But it's often less work. It's a lot of work to manage a construction project. And landlords, institutional landlords that do life science, they might have already done 10 of these a year, and they're very good at it. And they can do it quicker and cheaper and more efficiently. So that's why you do a landlord build. A tenant build will give you more cost control, more schedule control, more design control, and that's often a good way to go. But it's a business decision internally because it's a lot more work. In truth, build outs are often some combination of both. In which case, lease negotiations are usually about coordinating the two so that there's not conflicts. Key provisions. Lease commencement and rent commencement. The lease commencement date is the day when the term of the lease starts. So if you have a 5-year lease, it's the date when that 5 years starts. Rent commencement date is as it sounds, it's the date that you have to start paying rent. They're often not the same. They depend sometimes on this build out process. So if the landlord's handing over the keys, the rent commencement is going to be sooner. It's going to be probably the day they hand over the keys. You have to start paying rent. If the landlord's building, oftentimes the you have to start paying rent when the landlord finishes construction. So, and then if the tenant builds, unfortunately, most of the time, landlords won't agree that the tenant has to pay rent when the tenant finishes construction. They give the tenant a certain amount of time, and whether the tenant is done or not with their construction, at the end of that period, the tenant has to pay rent. And then there are rent abatements that get negotiated at the term sheet stage. All that means is that the rent commencement date has happened, but you don't have to pay rent for a certain number of months. It's an incentive, basically. Maybe the first 3 months are free. Second key point to know, really, really important point. There are additional costs. It's not just the base rent you see. It's very similar to nowadays when you buy an airline ticket, you pay a base price, but you know that's not all you're going to pay. You got to pay for your luggage. Maybe you have to pay to talk to a gate agent. Maybe you have to pay for food. And no different here. The base rent is not necessarily all you're going to pay. The big one, a big component of it is operating expenses. What are they? They are essentially all costs that the landlord incurs because it owns and manages this building. So it's management fees, repairs, maintenance, insurance, taxes, landscaping, all sorts of things. Everything that the landlord spends because it owns this building, the tenants collectively pay for. To demystify that somewhat, what is a triple net lease? What is a gross lease? Triple net means that the tenants collectively pay 100% of the landlord's operating costs on top of their base rent. And each tenant pays its proportionate share, which is basically, it's almost always the proportionate share is the square footage of the tenant's space divided by the square footage of the building or the project, and each tenant pays that. And that's an additional cost on top of your base rent that's fairly significant. I'm not going to ballpark it, talk to your broker about what it is, but it could be 30% on top of the base rent, it could be higher or lower. It's not an insignificant cost. In a gross lease or a modified gross lease, there's different variations on this, but the idea is generally that the tenant pays its proportionate share of any increase in operating costs. So for example, if the landlord's operating costs in 2022 were $100,000 and your base year is 2022, then in 2023, the landlord's expenses are $150,000. So $50,000 additional cost in 2023, then you're going to pay your proportionate share of just the $50,000. And there are different variations. You may be paying utilities directly to the utility provider, so that may or may not be included in your base rent. I'll gloss over audit rights. It's something that gets negotiated in the lease, but it's basically, just to demystify it, it's the right to audit the landlord's operating expense books to make sure you're being sort of charged correctly, they're accounting for it correctly. Quickly on some other things, property management fees, additional costs. The build out itself is likely to lead to additional costs. Again, the allowance may not cover the build out, and the tenant is almost always responsible for overages, whether it's caused by an unknown factor or whether it's caused by cost increases. Generally, defects can add extra costs. Known unknowns and unknown unknowns, to harken back 20 years ago. There's just a lot when you start construction that you don't know. You're uncovering the walls, you're seeing new stuff. And this is often where the most significant additional costs come up, is when you're trying to build out the project. So something to be aware of. There are ways to protect against that. And then there's some ways you just can't protect against that. Maintenance and repair. Oftentimes, the current market, the custom in the industry is that the tenant is responsible for repairs inside the box. So you're going to have repair costs for fixing lights, for fixing door handles, for fixing ceiling tiles, what have you. That's an additional cost. You have staff time devoted to that. Also gets negotiated who replaces expensive things like the air conditioning units. That's something that needs to be negotiated, because that can certainly be an extra cost too. Other additional costs to look out for: hazardous materials management. You have to do inventory reporting. At the end of the term, you need to hire a third party to do an exit assessment. If something goes wrong during the term, you're probably also responsible for paying consultants, environmental consultants. So that's an additional cost. Sometimes the tenant is responsible for its own janitorial. It's not included in the rent, so that's an additional cost. An obvious one would be parking. Is parking included or is it not included? Just depends on the location and the market. I have a little side note here. Be aware if you're next to a sports stadium. This really came up, but a client has space next to a football stadium, an NFL stadium, and on the weekends, the landlord, on the game day, on the Sundays during the football season, the landlord rented out the parking lot, for people going to the football game. And so if people tried to come into the office or the lab to use it on Sundays, they couldn't park there, or at least they could, but they had to pay, $60 to park there. So just a weird aside that I make, that, parking's something to think about. If you're next to some sports stadium, it's going to be even more something to think about. And then finally, restoration costs can be an additional cost. What that is if you make alterations to the space at the end of the term when you move out, do you have to rip those back out and restore to the space as it was when you first moved in. That can come up. Let's say you put in a clean room and the landlord's like, I don't need this clean room at the end of the lease term, get rid of it. That would add a huge cost. So that's something that gets negotiated through the lease process. What types of things are you required to remove? When does the landlord have to tell you? Some of those become issues in the lease. As mentioned, utilities and interruptions to utilities are a big deal. As California, utility provider is rolling blackouts. The landlord's not responsible for that. That's not their fault. It's not anybody's fault. Couple things. In an office building, heating and ventilation and air conditioning is not provided 24/7. So when I leave this building today at 6 o'clock, the temperature is going to go up to 80 on the thermostat and it's going to get warm in here. In general, labs need to be climate controlled. So one thing to look for in a lease is, are utilities actually being provided 24/7? Or are they only being provided during business hours? And then the big story here is that backup power is absolutely critical. A large production facility might have central utility plants and chillers, but all laboratory space and all uses, a big focus when you're doing your diligence on the space should be, what's the generator situation? Because that's ultimately what you're relying on. And this could be shared with the other tenants, or even better, you have your own dedicated generator. And then who's taking care of it? Who's doing the monthly servicing or the quarterly servicing? For the tenant's perspective, ideally, actually, it's probably better if the tenant does it, because then they know it's getting done. But that's just a negotiation and a key point to be looking out for. Hazardous materials are another key issue in each lease. A significant source of potential liability for both parties. But the main thrust is that the tenant, just if it's conducting laboratory activities, has to have the right to use hazardous materials. So if you have a laboratory and you use even small quantities of hazardous materials, and the landlord says you're prohibited from doing, the lease says you're prohibited from doing that, well, now you got a problem. You got to negotiate that away. That's a red flag. So what that looks like becomes a negotiation. Oftentimes the landlord will say, okay, I approve these chemicals and these quantities, but what happens if you need to change that? Well, that needs to be dealt with as well. And also, what are the reporting procedures? There's often extensive reporting procedures. The landlord's going to want to see your permits, your hazardous materials management plan. They're going to want to see any permits from the jurisdiction when you exit or close those permits out. So there's often reporting that goes on. So negotiations over what that's going to look like over the course of the relationship over many years is unique to life science companies and often a critical issue. Other key provisions, trade fixtures and production facilities. This one will require a little bit more explanation. First, what is a fixture? A fixture is something that if you picked up the building, flipped it upside down, and shook the building, anything that is attached to the building that doesn't fall out is a fixture. What is a trade fixture? It's a fixture that's used in the course of a business, in the course of the tenant's business. So that's not very clear, right? Because a sink is a fixture, and in the course of a tenant's business, it uses the sink, but it's not essential to its business, so it's not a trade fixture. The main thrust here, the main point here is that the lease should clearly delineate as best as it can who owns what equipment does the tenant own, what equipment does the landlord own, and what happens to it at the end of the term. Generally, as a general rule of thumb, the landlord's going to own, at least at the end of the term, the landlord's going to keep anything that they've paid for. Hopefully the tenant keeps everything that it's paid for. But this is this can be a big issue, who's taking the hood fans, right? At the end of the term, and then maybe you don't want them, and do I have to remove them now? Or can we keep them here? Those are issues that come up. Briefly, alterations. If you want to make physical changes to the space, you need landlord consent, generally. You can negotiate things that may not require landlord consent. And then, as mentioned in the additional cost section, what happens at the end of the term? Do I need to rip them all out or not? And when do we get to decide that? So those are, another negotiating point in leases. Restrictions on assignment and subletting usually requires landlord permission. I get asked, can I sublet the space? The answer is yes, but you need permission. Be aware that some leases will prevent a change in control. So if your company merges with another company and that other company now essentially has control of your company, that's a change in control, and it may require landlord consent. So big point of negotiations is, what can I do without the landlord's consent, right? Because generally, in my opinion, the landlord shouldn't have a veto right over the tenant's sort of fundamental business transactions. So that needs to be negotiated in a lease. Finally, briefly, relocation. Relocation is the right of the landlord to require, to force you to move from one space to another space in the building. That just should never be there for life science uses for practical reasons. And so, keep an eye out for it. If it's there, it's a problem, because you can't just up and move as an office tenant would. All right, we're only gonna have time to cover financing, and I'll roll through it relatively quickly so we can get done on time. This is when you have your own building, you want to raise money, what's going on? Okay, I just wanted to cover this because this is a common question, which is, should I own real estate? Should I, a company, own real estate through my operating company or through a separate LLC? And the short answer is yes. Yes, you should, where possible. A lot of lawyers will say there's some liability protection. There is, and I won't get into the complications of that because it's kind of boring. There is, and that's partly why it's a good idea. There may be tax and accounting reasons to do it. You should talk to your tax attorney and your accountant. There may be tax and accounting reasons to not do it. There may be practical reasons not to do it. Extra administration, let's say. But my answer is usually that if you're going to finance a building, the lender is going to require that the borrower be a separate entity from the operating company. So a typical structure for real estate ownership then is that you form a separate limited liability company, and its only asset is the real property. The operating company is its sole member, it's its manager, and then oftentimes in the financing, that LLC will then lease the property back to the operating company. Even though they're sort of one and the same, there's maybe an arm's length lease. I'll briefly touch on the types of financing that a life science company might acquire. Construction financing is short-term financing used to build a building, essentially. So it's money you draw down to pay the contractor, the architect, soft costs. Typically has a short term, 18 to 36 months, let's say, enough time to get the building done and stabilized. Typically has a floating rate, typically interest-only payments, and typically the borrower only pays on what it's drawn down from the loan. So if you have a $100 million construction loan, but you've only drawn down and used 50 million of it, you only pay interest on 50 million. It's a little bit different than a mortgage, let's say. Permanent financing is what you do after the construction loan. It's hard to give a rule of thumb about this because there's a lot of different ways to do it and a lot of different lenders and a lot of different flavors of it. But basically it's longer term financing when the property is now built and it's stabilized, meaning sort of it's operational, it's at market. It can be fixed rate, it can be variable rate, it can be fixed rate with an interest rate cap, lots of things and different ways to do this. Generally, principal and interest payments are required, unlike the construction loan. And like I said, many different structures and lenders. Sometimes a loan is a combination of both. But by far the one to know about that, that I've helped a lot of life science companies with over the years is a sale leaseback. And a sale leaseback is a hybrid between a sale and lease in the traditional sense, but it's a financing. It's a way to take your fixed asset, your real property, and turn that into cash without disrupting your operations. So it's pretty simple in concept. The company that owns the real estate, they sell the real estate to a buyer, and then the buyer, when they close, they've agreed to lease the property back to the company. And they all get signed at the same time. And the lease sometimes looks like a regular lease, but oftentimes it looks a little bit more like loan documents. And it's usually for a very long term, because the buyer, they're not buying your property because they really love the property. They're buying it so you pay them rent over a long term. Basically, you pay them back much like a loan. So it's usually a longer term lease, doesn't always look like a regular lease, but it's a way of raising capital and quickly turning relatively a liquid asset into cash. Some key issues, and then I'll wrap up. Business, think about the business term, whether this is a sale leaseback or a regular traditional financing. Think about the business issues at a term sheet stage again, a non-binding term sheet, but that's where your lawyer should review and the sort of big issues are hashed out: loan amount, interest rate, lender fees, all sorts of lender fees, prepayment fees, like you have to pay for the privilege of paying off the lender a little bit early. Sometimes there's an exit fee you have to pay for the privilege of paying off your own loan. And different kinds of guarantees. What does the operating company have to guarantee? Different loans require different things, different types of guarantees. A couple things specific to life science companies for all sorts of financing and sale leaseback. Will the lender have a lien on your production and manufacturing equipment? We talked about that equipment a little bit. Normally, in real estate finance, the borrower pledges basically everything it owns. And if the borrower owns a lot of very valuable equipment, that may not have been intended to include in the collateral for the loan. So that needs to be dealt with. Some of that's taken care of by having the borrower be this special purpose entity that doesn't own any equipment. But oftentimes, is that part of the collateral pool or is it not? And by collateral, I mean, if you breach the lease, if you don't pay the lender back, can they take that equipment away? Is that part of their deal? Same with the company's intellectual property. If the borrower is pledging all of its assets, does that include the company's patents and copyrights and everything else? That's an important issue. You don't want to accidentally give the lender the rights over, $300 million worth of patents for a $10 million loan. 5, consider the company's ability to finance trade fixtures. Same issue with the equipment. Now that we haven't pledged them as collateral, if I need to go and buy and fabricate a piece of equipment that's going to cost me $5 million, can I finance that separately from my loan? Or can I lease that equipment? That's a negotiation that needs to happen. Generally, the lender is going to limit how much additional debt you can take on. So that's a key issue that comes up for life science companies. Some lenders will allow that, some lenders will not. You can always ask for permission. And then, another big issue that comes up is negotiating the ability to make alterations. Much like a lease, what can I change without the lender's consent? Because the baseline is that the lender says you can't make physical changes without consent. Loan documents are going to be far more restrictive on this point than leases, but oftentimes there's room for negotiation. Let's say you're a CDMO and you're making changes all the time. You might have some more flexibility to accommodate because that is your business. That's how you're going to pay the lender back. Or if you're going to make changes, like in the course of the next 2 years, to disclose those to the lenders now and say sort of pre-approve them. Those can be big issues as well. Briefly, considering what happens if the building burns down, if it's destroyed in an earthquake, apparently, as we found recently, if it's sort of flooded by a hurricane, the base rule is that once you collect your insurance proceeds, you're supposed to pay off the loan, which is sort of unsatisfying from an operational perspective, because what you really probably want to do is fix the building with your insurance proceeds, because if you pay all of your insurance proceeds over to the lender, yeah, you don't have debt, but you don't have a building either, and you got to come up out of pocket to pay that. So generally, a borrower, you need the negotiated ability to rebuild using your insurance proceeds in limited circumstances with a lot of conditions, but my point being is that it's a key issue. And then finally, similar to lease issues, for corporate transactions, mergers and acquisitions, they're going to likely require landlord consent from your real estate lender. And, we can get around that on the lease side, but not necessarily on the lender side, especially in terms of a change in control. So it's just something to be aware of. It's negotiable around the margins, but that's something to just generally that can't. It is what it is. I'm going to skip development and construction because we're out of time, and I'm going to go right to, if anybody has any questions, I'm happy to answer any questions. And if anybody wants to email me or call me later, my contact information was there. But yeah, that's all I had. Okay. Well, I'm going to put my information up there, and then I'm going to, pardon your eyes, it's going to go real quick. and then I'm going to sign off. And I really appreciate everybody coming today to the presentation. If you're watching this recorded later, I appreciate you watching this, and feel free to email me, call me with any questions. I'm happy to talk to your company about any, other topics you want to talk about, or make a presentation to your company. And that's it. Thanks very much. Appreciate everybody being here. Thank you.